हेलो दोस्तों, आप लोगों का स्वागत है हमारे चैनल टेक्लॉस में। आज हम लोग बात करेंगे आर्टिकल 21 ए के बारे में, राइट टू एजुकेशन। ओके, सो राइट टू एजुकेशन इज लाइक डिस्कस इन आर्टिकल 21 ए। द स्टेट शैल प्रोवाइड फ्री एंड कंपल्सरी एजुकेशन टू ऑल चिल्ड्रन ऑफ द एज ऑफ 6 to 14 years in such manner as the state may be by law and determine. So this is article 21। अब देखते हैं आर्टिकल 21 में क्या क्या चीजें डिस्कस की गई हैं। ओके, सो आर्टिकल 21 of the Indian Constitution, human progress depend on the education. Okay, so any nation's future is depend on the quality of education system. Even while the member of the constitute assembly understood the value of the universal education, they were unable to guarantee it as a fundamental right because of lack of funding, despite the fact that it is listed in the directive principle of the state policy. The Indian judicial system attempt to include the right to education as a component of the right to life in 1993, the case of Umi Krishnan versus State of Andhra Pradesh. Through the constitutional amendment, it was passed in 2002. The Indian Parliament also gave its future inhabitant the right to an education. So Article 21 of in Indian Constitution, on some occasion both the judiciary and the parliamentary have the chance to clearly explain the nature of newly created fundamental right, particularly in the light of the possibilities that it might be conflict with the fundamental right of minors that already exist to create and run education institute of their choosing. There were a few crucial questions that need to be addressed: whether the Supreme Court decide in a aforementioned case include the right to education in the preview of Article 21, and the insertion of a new right along with the right to life has given the former and president over other related rights remain an unanswered question। 6 से 14 साल के बच्चों के लिए फ्री मैंडेटरी एजुकेशन इस एक्ट के द्वारा लोगों को दिया जाने की प्रावधान है। So right to children to the free and compulsory education act 2009, it gives the effect to the article 21A of the constitution. Right of children of free and compulsory education in 2009 was passed. It said that the state would provide free and mandatory education to the children between the age of 6 to 14. Okay, and incorporating the right to primary education. In 2008, 6 years after the Indian Constitution underwent the amendment of 86 Amendment 2002, the Cabinet approved the Right to Education Bill. The Cabinet adopted the measures on July 2, 2009. The bill was approved by both the Rajya Sabha and Lok Sabha on July 20, 2009 and August 4, 2009 respectively. The act was notified and legislature on the September 3, 2009. After receiving the President approval, with the exception of the state of Jammu and Kashmir, the law took effect of 1st April 2010 throughout the nation. The act provides for the following: every children between the age of the 6 to 14 has a fundamental right to free obligatory education in the school up to the completion of the elementary education. तो डेट मीन इस एक्ट में हर एक बच्चे को जिसकी उम्र 6 से 14 साल तक है, स्टेट को कंपल्सरी फ्री एजुकेशन देनी होगी। दैट्स द मेन थिंग। सो नीड ऑफ सपोर्ट एजुकेशन फॉर द गर्ल्स इन इंडिया, and according to the throughout investigation of the human capital theory, education significantly affect the productivity of the economy by raising factor production per worker. Plans for long-term economical development are centered on education and development of the human resources. Girls who feel unsafe and insecure also stop attending school. Boys attend the schools in the afternoon after girls do in the morning. So senior students frequently say that the boys follow them home after school while they are being teased. Due to the arousal of the several complaints surrounding such events, police officers were appointed for patrolling when the girls got out of the school. However, as soon as there were fewer police officers, the boys keep harassing the girls because their parents thought that it was no longer safe to send their daughter to the schools. Many girls dropped out eventually. So the issue still exists despite repeated report to the police and SMC members. So इसी बात पे हम लोग बात कर लेते हैं कि ह्यूमन कैपिटल जो थ्योरी है उन्होंने अपनी रिपोर्ट यूज की। उन्होंने कहा कि इकोनॉमिकली डेवलपमेंट के लिए सोसाइटी में लड़कियों का पढ़ा लिखा होना बड़ा जरूरी है। सो यहाँ पे जो स्कूल्स थे वो मॉर्निंग में गर्ल्स की शिफ्ट चलती थी और फिर बॉयज। सो बिकॉज बॉयज उनको टीज करते थे, छेड़ते थे, इस वजह से बहुत लड़कियों ने स्कूल आना छोड़ दिया। तो इस कारण से स्टेट पुलिस, बिकॉज वी डोंट हैव द इनफ पुलिस व्हिच इज कंट्रोल ऑल दीज थिंग्स, तो हम लोग के पास में इनफ पुलिस नहीं है जो ये सारी चीजें कंट्रोल कर सके। सो बिकॉज ऑफ ऑल दीज इश्यूज और इन सब प्रॉब्लम्स के कारण क्या हुआ कि बहुत से पेरेंट्स ने अपनी लड़कियों को, बिकॉज दे आर फील लाइक दे आर नॉट सेफ एंड देयर डॉटर इज नॉट सेफ इन द स्कूल, सो इवेंचुअली जो गर्ल्स थी उन्होंने स्कूल को ड्रॉप आउट कर दिया एंड ये प्रॉब्लम सोसाइटी में अब एग्जिस्ट करती है। So now I am just going to discuss one judgment like Mohini Jain versus State of Karnataka 1992. In this instance, Miss Mohini Jain, a native of Meerut, ये एक मेरठ की एक नेटिव थी, मेरठ की रहने वाली थी, and apply for the admission for the MBBS program as a private medical college in the state of Karnataka and session committing in 1991. So in the college administration required to her submit 60,000 rupees as the first year tuition fee as well as the bank guarantee for an amount equivalent to the charge for the following year. And the management declined to admit Miss Jain to medical college after hearing from her father that the requesting sum was beyond his financial capabilities. The administration alleged wanted to the additional fees of 4,50,000 according to Miss Jain, who testified in the court, but the management had denied such a claim. मिस जैन ने ये क्लेम किया कोर्ट में कि जो कॉलेज है उन्होंने 4,50,000 उनसे एडिशनल फीस की भी डिमांड की, जो कि उन्होंने कोर्ट में भी अपनी टेस्टिमनी में कहा, बट मैनेजमेंट इस बात से डिनाई करता था। सो व्हाट इज द जजमेंट ऑफ दिस केस? सो लेट्स सी। So Supreme Court ruled that in this case, even though the right to education as such has not has been protected by the Constitution as a fundamental right, it is obvious from the preamble of the directive principle of the Constitution that stated that was intended to provide education for its citizen. Additionally, they ruled that the private education institution, college of capitalization fees violate the right of the education that is implied by the right to life and human dignity and equal protection under the law. So इसमें बोला कि जो कैपिटलाइजेशन फीस है ये वॉयलेशन करता है राइट टू एजुकेशन का, राइट टू लाइफ का, राइट टू लिव विद द ह्यूमन डिग्निटी का एंड इक्वल प्रोटेक्शन अंडर द लॉ। सो उन्होंने इस जजमेंट में यही बोला कि जो आप कैपिटलाइजेशन फी है दिस इज नॉट द कॉन्स्टिट्यूशनल, ये फीस कॉन्स्टिट्यूशनल नहीं है। फिर इसके बाद एक दूसरा जजमेंट आया जिसने इसको रूल किया, उन्नी कृष्ण जेपी वर्सेस अदर्स वर्सेस स्टेट ऑफ आंध्र प्रदेश 1993. द केस चैलेंज द कॉन्स्टिट्यूशनलिटी ऑफ द स्टेट रेगुलेशन गवर्निंग द कैपिटलाइजेशन फीस लेविज बाय द सम प्राइवेट प्रोफेशनल एजुकेशन इंस्टीट्यूशन through petitions made by the private education institution to contest the state law. That case is given substance. The state of Tamil Nadu, Karnataka, Andhra Pradesh, Maharashtra created his state legislation to control the capitalization fee amount. The law stated that any additional fee received by the management employee would be regarded as the capitalization fees, and Supreme Court has observed that it would be the responsibility of the state to offer the facilities and opportunities required by Article 39 Clause E and subclause F of the Constitution to provide the exploitation of their infancy owning to distinctions and square. In Unni case, the court disagree with the ruling in Mohini Jain versus State of Karnataka 1992 and that constitutional guarantee that the right to education at all levels. Following the constitutional bench ruling in Unni the Supreme Court declared that the Article 45 has now been elevated to the status of the fundamental right in the case of MC Mehta versus State of Tamil Nadu in 1996. So, and after that, there is a one more judgment in 2008, that is a recent judgment, that point of time. Ashoka Kumar Thakur versus Union of India as another. So, Justice Bhandari essentially concurred with the other judges is sustaining the contest affirming action policies in the separate opinion in this case in what he believed is to be an introversion of the constitutional principle. He was harshly criticized the government for placing higher education and in particularly affirmative action in the higher education ahead of basic education. His opinion include obiter dicta of Article 21A in the context he planned for Article 21A to have two main कंपोनेंट सो आर्टिकल 21 ए के अंदर उन्होंने टू कंपोनेंट कहा है कि फर्स्ट ऑल द चिल्ड्रन ऑफ द अप्रोप्रिएट एज मस्ट attend the school, and second the education they get must be the quality education. So justice भंडारी ने कहा अपनी स्टेटमेंट में उन्होंने कंक्लूड किया कि there is only like article 21 की there is only two components. Okay, first कि जो चिल्ड्रन है अप्रोप्रिएट एज के लाइक 6 to 14 दे शुड बी अटेंड द स्कूल, एंड सेकंड द एजुकेशन दे गेट मस्ट बी द क्वालिटी एजुकेशन. Okay, so this is all about it. Thanks for watching the video. Thank you.